Ohio versus Margaret Katkowski, case number 24CR068. The defendant is present in the courtroom with her attorney, Nicolette Tomaszek. We're before the court this morning for purposes of sentencing the defendant, having pleaded guilty and been found guilty of 1 count F5 possession of cocaine, 1 count F5 possession of fentanyl-related compound, and 1 count F5 possession of drugs. Parties are ready to go forward, Your Honor.
Ms. Thomas, is there any reason not to go forward with sentencing?
No, Your Honor, we're prepared to proceed with sentencing.
Anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would just like to ask the court today for any leniency in sentencing for Ms. Katkowski. Your Honor, with Ms. Katkowski, I've had an opportunity not only to speak with her, but also one of her very close family members. She does have a good support system, Your Honor. Ms. Katkowski does have a history of drug use. She has been using drugs since she was a teenager. She has done some treatment in the past, Your Honor. I don't have confirmation whether that's been completed or not. She did have an opportunity in Cuyahoga County to attempt for intervention in lieu. She was in the CBCF there actively participating. However, due to some medical issues, they did release her from the CBCF and did terminate her probation there, Your Honor. In speaking with Ms. Katkowski, it's clear she does have some mental health issues, Your Honor. It's from the start of this case to now, it did take some time for her to fully trust me, be able to talk to me and give her perspective, Your Honor. So we'd just like to ask for any leniency in sentencing. It is clear that Ms. Katkowski does need help, especially with her drug use, but also for her mental health issues. Our office has attempted to get her set up either at ORCA or some other facility, but unfortunately we were unable to complete that process, Your Honor. So like I said, we just asked the court for any leniency today. Thank you.
Ms. Katkowski, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I just asked the same thing for any leniency.
Why do you deserve leniency? I tried to give you leniency. We were here a couple weeks ago, and I continued it to try to get you help, and you refused to talk or meet with anybody. So my hands are tied right now. Well, why do you deserve leniency if you're not even willing to meet with somebody, to talk to them, to try to figure out what kind of help I can give you?
I've just been struggling with my mental health, Your Honor, and
that's why people were trying to meet with you, to get you help for that. And you refused to meet with people multiple times. You got to give problems this morning. That's why you're sitting there with your hands cuffed behind your hand or your back, because you were giving the COs and deputies a hard time today, refusing to even come here. I mean, these people came to see you to try to help you, to try to get you help for this mental health issues that you say you're struggling with. You wouldn't even sit down and talk with them. And it's been the history. This whole case, this happened 3 years ago because you wouldn't come to court, you wouldn't do anything. And now I'm supposed to give you leniency? You really think you deserve that? For the way this case has played out? And the way you've dealt with everybody?
I did do an assessment with Lake Geauga.
I continued the sentencing when we were here last time so that you can meet with people to try to find out the best program for you, and you wouldn't even talk to them. I mean, my hands are tied here. I got nothing more I could do. Is there anything else you want to say? Is that a no?
Or just,
We can't take up the shaking of your head, so you need to verbalize your responses.
I would just ask for a second chance.
All right, Mrs. Thomas, got anything else?
No,
A
Your
second
Honor.
chance at what?
To do the right thing.
Which is what?
Get better.
Sorry?
Get better.
So what do you want a second chance at doing?
To get better.
Mrs. Thomas, got anything else?
No, Your Honor. Thank you.
Shapiro for the State of Ohio.
Thank you, Your Honor. A lot of people want the defendant to get better, but the state does not believe that the defendant is amenable to community control for some of the reasons that outlined in the pre-sentence report and as Your Honor highlighted this morning. So the state would have to recommend prison in an amount that the court feels is appropriate. The defendant does have credit for 155 days already served.
This court has reviewed the pre-sentence report and investigation that was completed. The drug and alcohol evaluation that was completed. Considered the facts and circumstances of the offenses involved, the nature of the offenses. I've considered the entire history of this case that started in 2021. And it's been delayed because of the defendant's failing to appear for hearings. It has nothing to do with the court or the dockets or scheduling. Consider what's been said here today. All this is considered only the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, nothing stands out factually making it more or less serious. As for recidivism factors, the court finds the defendant has a history of criminal convictions, that she has failed to comply with previously imposed sanctions ordered by court. She's been on probation before. She's violated for not reporting multiple times. She was on probation to Cuyahoga County when this occurred. There's clearly a drug problem that relates to the offense, and she denies the problem and is refusing treatment. We've attempted to get her assessed multiple times. This was scheduled for sentencing previously. There was nothing set up for her that was going to work. I continued to provide more time to find a treatment facility that could deal with her issues, and she refused to meet with anybody. Multiple occasions. Attorney, social worker went over to try to talk with her, and she wouldn't talk with them. So she's refusing any help. She failed to appear for court hearings in this case. As I alluded to, the offense was committed back in 21. There was a warrant issued out of municipal court on the initial case that was out for a while. This case, she failed to appear for her trial. No factors indicate recidivism is less likely. Under 29-29-13b1, court notes the defendant was on probation at the time to our community control sanctions to Cuyahoga. She violated her bond in this case by failing to appear for court hearings. And there's no way the court can make any findings. She's amenable to community control sanctions when she won't even meet with people and talk with them to try to get help. So I'm telling her, I want to give you help, and she won't even talk with anyone to get it. She just wants to do things her way. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that counts 1, 2, and 3. Defendants serve a term in prison of 9 months on each count. Run them concurrent. She has credit for 155 days she's served. I'm going to forfeit the contraband and instrumentalities. Need to advise you upon your release. You may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence here today. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant's ordered to pay all costs. Do not release any, don't put anything about bond. Bond was previously forfeited, I believe, so I don't want any confusion created down there with that.